This courtroom hearing quickly turns into absolute chaos when Mr. Thornton, a self-proclaimed sovereign citizen, decides he's going to represent himself. From the very beginning, you can feel the tension building. Instead of addressing the charges in a normal way, he starts making bizarre claims, insisting he's not the person named in the case, but merely the shoulders attached to that name. Yes, you heard that right. The judge pauses, clearly trying to process what's happening, while the prosecutor looks increasingly concerned. As the hearing continues, it becomes obvious that Mr. Thornton doesn't fully understand basic legal procedures. The judge patiently explains what a preliminary exam is and warns him about the serious risks of self-representation. But Thornton refuses to back down. He insists he knows what he's doing, even as his arguments grow more confusing and disconnected from reality. Things take another turn when the prosecutor raises concerns about his competency. The courtroom atmosphere shifts from frustration to concern. The judge, maintaining remarkable patience, decides to delay the preliminary exam and orders a competency evaluation to determine whether Mr. Thornton is even fit to proceed without an attorney. At the same time, the court ensures he receives all discovery materials so there's no claim of unfairness. By the end of the hearing, the judge reschedules the probable cause conference and once again reminds Thornton that he has the right to counsel if he changes his mind. It's a powerful reminder of how the justice system balances individual rights with courtroom order. What starts as defiance slowly turns into a lesson about reality and the limits of courtroom theatrics.
You state your name for the record, please.
I am Shoulders in here by way of Executive Office for Latavia Sheshad Thornton nonprofit organization.
Accept that as Mr. Thornton announcing his appearance before the court. We are here this morning for a pre-exam conference. Mr. Anid, it is my understanding that Mr. Thornton has declined representation. However, Mr. Thornton, at every appearance, I need to remind you that you have a constitutional right to be represented by an attorney, and that if you can't afford an attorney, the court will provide one for you. I am particularly proud of the superb public defenders we have in this court. However, you may also retain any attorney you wish. You will get to choose the attorney. You would have to pay them. You have a constitutional right to represent yourself, but I have to warn you that if you proceed representing yourself, you would be held to the same standard as all attorneys who have gone to law school and passed the bar and been admitted to practice. So the court really can't give you any breaks or help you at all. Is it your wish to represent yourself, sir?
Mr. Thornton is aware of the courtroom decorum and the standards and procedures that must be upheld by a person in representation of a party. And as again, Shoulders, I am aware that I do have constitutional rights, not just the ones that were mentioned here before, and also that the exercising of a right is also an expression of a right, which is an invoking of a right, which is a way that a right can be used and to uphold the proper standards. Mr. Thornton does not wish to get public counsel representation as I am a legal representation by special appearance through the executive office for Mr. Thornton and not the actual entity, Latavia Sheshad Thornton. Once again, on the record, it has not been declined that Latavia Sheshad Thornton is a nonprofit organization, which, yes, Your Honor, is a person, in fact. And I, the man speaking with a voice and a sound mind.
So I'm going to cut this off. I don't want to mute you, but we have to move forward. We have an attorney standing by. That would be Mr. Foreman. Have you had an opportunity to speak with Mr. Thornton about any plea offer?
No, Your Honor, and I don't think I'll have any meaningful conversations with him based on what I see. I believe that it's not clear whether what he's doing is intentional or whether this may be a competency issue. But I'm prepared to proceed. I just don't know if we should. I have a concern for his competency, to be honest with you. If the court
Objection.
we had the same issue last time.
No, Mr. Thornton, one person at a time. And right now, Mr. Annette is speaking.
I mean, I guess I would inquire with whether he knows what a preliminary exam is, and if he understands, if we forward, if he's gonna know what to do. I mean, I believe I have to look at the court rules. I've never dealt with this issue, but I think having standby counsel would be something that would be needed to advise him. I'll look into all that, but I just don't know if he's gonna know what a preliminary exam is. I believe this may just be a competency issue. I don't know, Your Honor.
Okay, so actually that's a good question. So Mr. Thornton, I'm going to ask you, what is a preliminary exam?
Well, before I address that, may I address
No,
it to
sir.
you?
No, we're gonna focus our answers here. What is a preliminary exam?
Your Honor.
I'm going to give you
Your
one
Honor.
chance to answer. What is a preliminary exam?
A court proceeding. Mr.
Okay,
Thornton
and
said
what?
that.
Okay, and what happens? That's a good answer. What happens at that court proceeding?
Preliminary examination, court proceeding. The parties have the opportunity to present evidence, cross-examine each other, and determine whether whether evidence is admissible to go into continuing proceedings, whether the court has jurisdictions. A plethora of matters may be brought up in a preliminary examination to see if the court has a valid standing, to see if there's anything, to see what may be addressed that's necessary as far as the parties that are at hand, not only to go about things in one specific fashion.
Well, that's pretty. That's a pretty good answer. However, at this point, given a review of
Your Honor,
history, the court is going to sua sponte suggest that a competency exam be ordered. Mr. Anid, any response?
I agree.
Okay, thank you. Mr. Thornton, any response?
Mr. Thornton does not believe that a competency exam sua sponte is necessary and objects that as a preliminary exam is something that we can proceed to and we can address the matters and the situations that are necessary at that time. And for the sake of due process and the judicial precedence of due process, that a criminal or a competency test may delay that, and it could hinder not only Mr. Thornton, but the things that Mr. Thornton does as far as the community and his career and his family and his life and rights, and other people that may be affected by this matter, as well as the public. Because for the judicial precedence is that Mr. Thornton is innocent and not guilty.
So, Mr. Anid, are you going to prepare a proposed order or?
Your Honor, I think it's been a while since I've done. I believe if I'm not mistaken, it's the. I can if you want. Yes, I'll prepare an order.
All right. So, at this time, Mr. Anid, comments on his preliminary exam?
No, I just say we just make the preliminary examination to be determined date. If anything, reset it for another PCC or review hearing for when we do come back with a competency opinion. Okay.
So, Mr. Thornton, you have two rights at play here. One is the preliminary, have that within 21 days. So, the reason that you have a right to have that within 21 days is to prevent cases from dragging on endlessly. There are certain timelines that have to be met. However, the court can waive that 21 days if it finds good cause. And that would be, for instance, if one side had recently received discovery and was unable to proceed. Another good cause could be if someone was ill or hospitalized. There could be any number of good reasons. So I'm going to ask you, actually, Mr. Thornton, have you received any discovery in this matter?
I have not. Mr. Thornton has not received any instrument.
Okay, so, all right, two things then. First, I find good cause to waive the 21-day rule, and we will get
Objection, Your
a
Honor.
date. No, sir, just a minute, let me finish.
I'd like to
You
see
can't,
without
you
discussion.
don't, no, listen, I don't want to mute you, but I have to get through this. So, you have to have, you have a constitutional right to have knowledge about your case. And if you haven't received any discovery, we can't go forward until you receive it. So two things. First, I'm going to waive the 21-day rule. And just a minute, Mr. Ed. We're going to waive the 21-day rule, and we're going to set a date out in about a month. That'd be a placeholder date. At this point, because you are representing yourself, I am going to allow you to converse with Mr. Anid, recognizing that you do not have discovery materials, so I do not expect this court to accept a plea bargain today. We're going to put you both in a breakout room, and when you're done, the court will be ready. Thank you. Okay, sound is back on at the jail, so we will go back on the record in the matter of People versus Latavius Rashad Thornton. This is case 25-0203-FY. Mr. Anid, prosecutor, and Mr. Thornton, representing himself, have met in a breakout room. So first, because the prosecutor has burden of proof, I'm going to ask Mr. Anid first, then Mr. Thornton, I'll ask you. So Mr. Anid, anything from the breakout room that you'd like to report?
Yes, I just want to make sure Mr. Thornton is there because I don't see him on here.
Oh, I see him.
Okay. Can you hear me? Okay. Yep. So we discussed. Yep. We discussed a little bit of as much as we could. I believe based on my discussions with him, I don't believe this is a competency issue. I believe this is more of the what Mr. Thornton kind of described earlier. So the plan, I think we both agreed on, is we're asking for another probable cause conference. I'm going to somehow figure out how to provide him discovery, the complaint, the information, all the charging documents that we have. We're going to come back. In the meantime, I'm going to do my due diligence to speak with our office to see how we're going to go forward with this. Because I know, it's my understanding he wants to represent himself. That is his right. I believe based on the questions that you asked earlier, he answered them pretty fairly, Your Honor. I just want to make sure we got all ducks in order. I discussed a misdemeanor offer potentially with them, but also discussed that I encourage him to get a public defender. All these things I think we're going to discuss at the next probable cause conference. I think these are all appropriate matters so I can get my ducks in order. He can have discovery to know what he's looking at. And I believe at the next hearing, we will have a good understanding of what we're doing going forward.
Mr. Thornton, is that an accurate report?
It's pretty accurate, Your Honor. Just a few more points that we had discussed in that breakout room was also that it was in the discovery, we would like to get subject matter in the appointment of the authorities that has been filed onto the record for these proceedings and how we came about to be into the court's jurisdiction for this matter in such fashion. And I think that's kind of
that's a word salad. It's not making any soup. Can you make sense at all? Can you rephrase that for me, Mr. Thornton?
Okay. So just pretty much all in the discovery, we didn't want any documents that have been filed onto the case to be missing, and that's what I mean by not limited to the documents titles that he named. It include an inclusion of all documents filed with all titles under them.
Okay.
I'll chime in
Mr. Ned.
And I think kind of what he may be talking about is, and I could be wrong, is the charging documents, what gives us the authority to proceed forward and how we're proceeding forward. And I explained you should wait until you discover it because I believe that's going to be the complaint, the information, and the other charging documents to see where we're at. I could be wrong, but once he receives those, we'll come back. We'll have all the ducks in order. I think that's a good resolution we both agreed on. And in the meantime, I'll do my due diligence to speak with our office to how we're going to go forward. I told Mr. Thornton, I'm the prosecutor. He understands what the prosecutor is. I'm not on his side, but I did advise I'm here to help get the situation. I think we both agree that if you find good cause to adjourn this for one more probable cause conference, I believe everything will be situated.
Mr. Thornton, anything further this morning?
Not at this time, Your Honor.
Just new dates. New dates. Our new probable cause.
Okay, so we had the dates, and that is 8:30 a.m. April 25th for a probable cause conference, and 9 a.m. May 1st for a preliminary exam.
Okay, so the next probable cause conference is about a month away. Does that sound right?
Yes.
Okay. All right.
So, Mr. Thornton, if at any time you change your mind, you can communicate with the court and or Mr. Anid about requesting counsel at every hearing.
This courtroom hearing begins like any other routine appearance on a busy docket, but within moments it becomes clear that this is going to be something entirely different. The judge calls the case of Mr. Thornton, and from the start there is an unusual energy in the room. Thornton, identifying himself as a sovereign citizen, makes it known that he intends to represent himself. That single decision sets the tone for everything that follows. The judge immediately shifts into a careful and deliberate explanation of rights. She reminds Thornton that he has the constitutional right to an attorney and that representing oneself is almost always a risky decision. Her tone is calm, professional, and patient. She explains that if he chooses to waive counsel, he will be held to the same standards as a licensed attorney. Court rules, rules of evidence, procedural requirements, all of it will apply to him exactly as they would to a seasoned prosecutor or defense lawyer. There will be no special allowances simply because he is not formally trained. Thornton insists that he understands. But as he begins to speak more, it becomes clear that his understanding may not align with reality. Instead of addressing the charges in a straightforward manner, he starts making unconventional claims. He suggests that he is not the legal entity named in the charging documents. He refers to himself in abstract terms, implying that the name on the paperwork is separate from the physical person standing in court. At one point, he describes himself as merely the shoulders connected to that name. The phrasing is confusing, and you can sense the shift in the courtroom as everyone tries to follow his logic. The judge attempts to clarify. She asks direct, simple questions. Do you understand the charges? Do you understand the maximum penalties? Do you understand what a preliminary exam is? Thornton's answers are indirect. He circles around the questions, often responding with ideological statements rather than legal ones. The prosecutor watches closely, clearly concerned. The judge carefully explains the purpose of a preliminary exam. She states that it is not a trial. It is not the moment to argue every detail of the case. It is a procedural hearing designed to determine whether there is probable cause to move the case forward. She outlines how evidence will be presented, how witnesses may be called, and how cross-examination works. She emphasizes that if he represents himself, he will be responsible for questioning witnesses properly and following evidentiary rules. It is not a casual conversation, it is a structured legal process. Thornton maintains his stance. He repeats variations of sovereign citizen rhetoric, challenging jurisdiction, questioning the authority of the court, and implying that certain legal technicalities invalidate the proceedings. These arguments are not new to the legal system. Courts across the country have encountered similar claims, and they have consistently rejected them. Still, the judge does not dismiss him outright. She listens. She responds point by point. She attempts to anchor the discussion in actual law. As the exchange continues, the prosecutor raises a significant concern: competency. This is where the hearing takes on a more serious tone. Competency is not about whether someone's ideas are unusual. It is about whether the defendant understands the nature of the proceedings and can assist in their own defense. The prosecutor notes Thornton's unusual statements and apparent confusion regarding basic legal concepts. The question becomes unavoidable: does he truly comprehend what is happening? The judge pauses and considers. She asks Thornton additional questions designed to assess his understanding. She explains again the charges, the potential consequences, and the structure of the upcoming hearings. Thornton's responses remain scattered. He appears confident, but confidence is not the same as comprehension. In order to protect Thornton's rights, and to ensure the integrity of the process, the judge decides to order a competency evaluation. This means a professional assessment will determine whether he is mentally fit to proceed. It is not a punishment. It is a safeguard. The legal system requires that defendants be competent before standing trial. If there is doubt, the court must address it. Because of this decision, the preliminary exam is delayed. The judge also ensures that Thornton receives all discovery materials from the prosecution. Discovery includes police reports, evidence, witness statements, everything the defense is entitled to review. The judge makes it clear that regardless of the unusual arguments being presented, Thornton's procedural rights will be fully protected. Throughout the hearing, what stands out most is the contrast between Thornton's defiant posture and the judge's steady patience. She does not ridicule him. She does not escalate. Even when his statements become repetitive or legally irrelevant, she responds with measured clarity. She reminds him repeatedly that he has the right to counsel. If at any point he decides he wants an attorney, the court can appoint one. That option remains open. Thornton, however, seems determined to maintain control. He expresses distrust of the system. He frames himself as separate from the legal identity being prosecuted. He challenges terminology. He attempts to reframe the proceeding on his own terms. But the courtroom operates under established law, not personal philosophy. As the hearing draws closer to its conclusion, the judge reschedules the probable cause conference and the preliminary exam, pending the results of the competency evaluation. She reiterates the importance of cooperation with the evaluation process. She stresses again that legal proceedings have structure and that participation in that structure is not optional. The atmosphere in the courtroom is a mixture of tension and restraint. There are no dramatic outbursts, no shouting matches, but there is a steady undercurrent of friction. On one side stands a defendant rooted in sovereign citizen ideology, convinced that certain legal formulations shield him from prosecution. On the other side stands a judge grounded in statutory law and procedural requirements, tasked with ensuring fairness while maintaining order. The hearing ultimately becomes less about the original charges and more about the clash between ideology and institutional reality. It highlights the challenges courts face when defendants reject the legitimacy of the system itself. It demonstrates how the justice system responds, not with immediate punishment for unusual beliefs, but with careful evaluation and procedural safeguards. By the time the session ends, one thing is unmistakable: the legal process continues forward. Delays may occur, evaluations may be ordered, hearings may be rescheduled, but the structure remains intact. The judge's repeated reminders about the right to counsel echo as the final procedural notes are placed on the record. The system moves deliberately, step by step, regardless of personal theories or unconventional arguments. What began as a standard hearing evolved into a revealing look at how courts manage self-representation, competency concerns, and sovereign citizen claims. It is a reminder that in a courtroom, belief does not override procedure, and ideology does not replace established law. The process may bend to ensure fairness, but it does not break.